Good morning, friends. I'm calling from Dublin. So this is the morning time, but good evening to all our Indian friends. I extend a very warm welcome to our 177th webinar on understanding front running, exploring basis, laws and regulatory compliances. As you are aware, friends, we have conducted 176 webinars over the last 4 years with over 1,15,000 participants registered, more than 120, 250 panelists, including judges, members, parliamentarian, IAS, IPS, IRS officer, regulator from MCA, SEBI, IBBI, CCI, former regulators, industry leaders, and professional from the corporate and practicing professional. Those who have shared their knowledge through this platform. Now, friends, today's topic is very interesting, and that is a front running, because understanding front running, normally it is a part of the insider trading. But when we see this particular concept of front running, then in the evolving landscape of Indian securities market, front running has garnered significant attention. Now, what is happening? The SEBI, because they have to promote regulation and they have to curb such type of practice, which is coming under the FUTP. But this is a one part of the FUTP because it's a front running is an unethical trading activities where individual or entities exploit advanced knowledge of impeding significant transaction of other entities to gain unfair advantage in the market. The question is, advanced knowledge is required in insider trading also, here also, but here is the difference. Here it is not the public at large, but here in the institution, you are doing trading with the knowledge of your institution. Somebody is buying and you are executing the transaction. So before executing this transaction, you are buying. So impact of this may not be that serious, but it has a impact. And it is an impact that you are first buying your shares and then you are buying client shares. So this is unethical things, and SEBI wants to curb this. So to address this concern, SEBI has recently passed several orders and they impose penalties on accused person, hefty penalties. That is 30 crore in one case. These actions underscore the regulator's commitment to maintaining market integrity and ensuring level playing field for all participants. The objective of this webinar is to provide a comprehensive understanding of front running, its implication for market integrity, and the regulatory framework that exists in India as well as internationally. And for this, we have invited none other than the person who has passed various orders and who has created the regulatory framework strong. So people should avoid these types of things. So I welcome our chief guest, Mr. V.S. Sundaresan. He is Executive Director in SEBI. He has more than 32-year experience in development, regulation and protection of interests of the investors in the Indian security market, and has worked in various departments of SEBI. He had supervised more than 500 investigation cases of market manipulation, insider trading, takeover, public issue, collective investment scheme, complies with the continuous listing requirement, and the most important thing, front running cases, which he has done. Because the front running is not easy as compared to normal insider trading. So we'll discuss this, what are the complexity in this. He strongly believes that's the most important part, to share knowledge, and he has delivered more than 350 plus lectures across India as well as 35 plus in international, and he is discussed on various topics which are related to securities market. And the most important thing about Mr. Sundaresan is that he is very open to ideas, discuss about those who are facing problem. He wants to understand this, because ultimately when you are making a law, the best part is you take the feedback from the market, which he is always ahead doing this. So I welcome Sundarshan sir for this program, and your word of wisdom and your experience and your insight will help everybody to understand that how much complexity of these cases and how you are cracking this. Welcome to you, sir. Then I extend a very hearty welcome to our learned speaker of today's webinar, Mr. Ali Asgar S. Mithwani. He's a Chief General Manager in SEBI. He has worked in various departments of SEBI, market intermediaries, regulation, supervisory department, investigation department, integrated surveillance department, and the Office of International Affairs. And he's one of the I should say, very intelligent officer of SEBI who understand the subject and who commands the things and who go deep into this to identify the problems and identify and cracking the case. I welcome Ali sir for this program. Then we have Mohini Vashne, partner head, ESOP and insider trading law in corporate profession. And then Mr. Ravi Prakash, associate partner, security law, corporate litigation, corporate profession. So friend, today's program structure will be like this. First, after my initial introduction, I will request Mr. Sundarshan sir to give a initial remark, and then Ravi will talk about the law, and then I'll request Mr. Ali sir to discuss the case laws and certain things and how and what are the problems, what are the things, and how this type of things is identified. Because I told you earlier also, it is not easy thing to catch hold somebody. Now, it is just like that someone in the company is doing trading, which is a normal course, and in the process, he is doing his own transaction. To catch hold of this is really difficult, and we will understand how this. And the most important thing, question comes, what is front running? So, front running in India refers to unethical and illegal practice where broker, dealer, and other intermediaries. Now, this is confined to these people because when you place order to the broker, he is buying your shares, but before buying, he is buying his own shares. Now, the question is, normal trading will not affect. Suppose you are saying 100 shares you are buying, and the broker is also buying 100 shares, that is not affecting. But sometimes institutional investor or big investor or HNI who's buying 10 lakh share, 5 lakh share, which can move the market. And then before doing this, he is buying his, or somebody is selling. So before this, he is selling his first. So you can understand when somebody bulk selling will come and you have sold first, then you can take advantage of that arbitrage. So this advanced knowledge of pending order from the client to execute trade or for their own benefit before executing client's order, this is front running. This practice exploits non-public information to gain an unfair advantage, impacting market integrity and investor trust. Friends, when we talk about this front running, I think its credit goes to SEBI that when you were doing trading long back, when there was no trading transaction confirmation system, that time it was rampant in everywhere. Every broker was doing front running, and that was front running. That time it is not, and that front running was in different way. So broker, what they were manipulating, you have given order, and the market has gone up, and he has purchased your share. Then he can deny that share has not come because there was no system to get, and there was no system to inform immediately also that time. And then second is, suppose you want to do some reverse transaction, and that time also he is taking some position in such a manner and refusing that your transaction sold at lesser price. So that time everywhere manipulation was taking place in India, and the maximum brokers were doing this. But now SEBI has come out and they started asking order confirmation. You can check your order contract note system. So this is an old system, but now this is a new type of manipulation, which is front running. So here the institutional investors, say mutual fund, plan a purchase a significant number of shares in large cap Indian company, say company XYZ. The mutual fund place an order with a brokerage firm to buy 5 lakh shares of companies XYZ, but their dealer, they realize that because this mutual fund is buying, so the market will go up, or if they are selling, market will go down. So he do his transaction first, and then he can take this advantage. So friends, the process is, you can understand, is complicated, and I just give my congratulations to the SEBI team that they have come out these types of complexity inside the company's room, where you can't reach easily, the information cannot reach. You are cracking and bringing out these information. Regulatory framework is very clear. It is unfair trade practice, which SEBI has passed, and especially target front running. Section 15 HA of SEBI Act impose penalty, and Master Circular Mutual Fund outline restriction of front running. The front running is not only in India but across the world. So international practices, US market, the Financial Industry Regulatory Authority enforce strict rule against front running. EU market abuses regulation also include provision against front running by intermediaries and third party. And only thing is, there are some challenges with this type of investigation. Providing front running requires detailed surveillance and evidence gathering. That is two important things we have to understand, including the analysis of trading pattern and communication record. Now, in the entire process, trading pattern is most important. He can say, but you have to identify it. As a regulator, they have to identify it and see the trading pattern is different. Suppose you are not purchasing normal shares, but suddenly you have purchased something, and other than this, you have not purchased. So you can understand these types of complexity SEBI faces. The involvement of overseas entities also sometimes create problem. So this is the things. And recently we have seen the three major case: Axis Bank, Reliance Securities case, and HDFC, where the dealer and their officers has done trading, and SEBI has imposed penalty on this. Now, sometimes the question comes, how SEBI prevents such activity? As an outsider, as a market person, I can just see a regulatory framework that prohibits fraudulent trade practice, that law they are making. Then they do surveillance. Surveillance, that is an automated surveillance system. How they track, what are the things, that is a very complicated system, but that is a very sophisticated thing which SEBI identified. Then they have to do enforcement action, investigation and penalty. Now, first they have to do investigation. They have to give chance to the other thing, and then put penalties. Then they provide compliance measure, like they have passed the mutual fund regulation also 2020, because this is the base. This is on the base of that how you should restrict your people, and what are the things, what do's and don'ts you should not do. Like we have seen in the cricket, the bookies were doing something that, and they were doing this type of manipulation. So now they have stopped taking mobile phones. They are not allowed to meet people during after some time. They want to inspect the pitch, then they can't go outside and tell somebody their mobile phone restriction is there. So many things, different things, different process is going on. So all these things we will work out, and it's not, there are so many challenges also with SEBI, which I told you: gathering evidence, analysis of trading pattern, and communication of record communication. Communication record is also very important. So these things we will discuss threadbare today, and how SEBI has come out with this. So friends, without taking much time now, I will request Sundarshan sir to give his opening remark. Before that, I just want to announce our next webinar, that is 177. That will be on the very topical subject, revisiting significant beneficiary owner, SBO, under the Companies Act on 21st June 2000, on next Friday on 2024. And friends, this webinar which we are doing, you have seen recently, Ministry of Corporate Affairs ROC has imposed penalty on LinkedIn and other big player internationally. So you can understand this is a very hot topic nowadays. Before this, I request Sundarshan sir to address us and tell us this complicated investigation process, which is totally different from normal insider trading. Over to you, sir. Sir, I'm calling from Dublin, so please excuse me my dress and some logistic issues.
Good evening, Mr. Pawan, and good evening to the participants. It's always a pleasure, accepting the invitation of corporate professional, because I always believe that in the process of attending these type of seminars, more than the knowledge I share with the participants, I actually learn more from the the type of questions being raised and the type of answers given. So it is actually a mutual benefit, and I actually acknowledge corporate professionals, and especially Mr. Pawan Kumar Vijay, for giving this type of opportunity. So for me, the location or the dress does not matter. What is the knowledge I gain from this is more important. So it does not matter to me where you are and how you are dressed up. I am more interested in the takeaways from this program. Let me come to the point directly on this front-running subject. As Mr. Pawan has very detailed explanation he has given, I just wanted to bring out certain nuances in the term which we are calling as front-running, and how it is different from the normal understanding as if it is also insider trading. If you see the SEBI Act, Chapter 6A of SEBI Act, which deals with what are the activities which are actually prohibited. Normally, what are the activities permitted is given, regarding registration and other things. But Section 12, capital A, specifically gives 6 types of activities which are not supposed to be done in contravention of the regulations made therefore. In that, one of the things is insider trading, that is 12, capital A, small d, and there is a separate provision called Section 12, capital A, small e, which says, the section starts like that: no person shall directly or indirectly deal in securities while in possession of material or non-public information which is in contravention of the provisions of this act or the rules or the regulations made thereunder. So the important point in front-running is that there is a person who trades, and whether the trading pattern is based on or dependent on some information which is non-known to the public and which is exclusively known to him. So the point is, information asymmetry comes in the picture. If it is known to the public, then there is no information asymmetry. If the information is known only to the person who trades and maybe 1 or 2 more people, then all these people who are expected, all these people who are having knowledge of this non-public information are not supposed to be in that security. That is the restriction which the law says. Now, and this provision, I should definitely compliment my predecessors. Way back in 2002, this provision was brought in. Those days, as Mr. Pawan pointed out, generally, because the trading instructions are given to the dealers of a broker, the dealer is expected to know what type of transaction the client is going to undertake, and therefore the dealer, in advance of knowing that information, instead of executing the order of the client, he will execute the same order. That is, if the client wants to buy, the dealer will buy in his own name or in his proxy names, and whenever he actually does the buy order of the client, he will reverse his position which he took earlier. That means he will sell, which is called, in our parlance, for the sake of understanding, it is called buy, sell. Similarly, when the client of the broker wants to sell, before executing the order of the client, the dealer will sell from his own account, although he may or may not have the stock either in his own name or in his proxy names. And whenever he actually executes the sell order of the client, he will sell his own securities, which he will buy those securities so that the contract happens and it becomes an intraday transaction. This we call as sell, buy. So that the entity which actually trades does not take any market risk at all, because he knows what he buys can be sold on the same day. He knows who is going to be the counterparty and who is going to come. Similarly, in a sale transaction, once he sells, he knows he need not have to give delivery, because there is already a buyer waiting, the seller waiting for that, so that he will buy from that and his position will get squared off. So generally, this front running was taking place with the broker's office on an intraday basis. Now, especially after COVID, what has happened is that people are allowed to trade from anywhere. Of course, earlier also this facility was provided, but especially after COVID, because of this digital infrastructure improvement and technology advancement, people are able to trade from different places. So people are taking advantage of this, the technological advancement, and any big order. Now, it is not necessary that the person is actually the dealer of the broker. Even within the same organization, if there is a big treasury department, there are many what you call institutional investors today. They have a separate trading or desk in their own office. The person who comes to know that there is going to be a large order to be executed for that institution, either he can do the same thing, or he can pass on that information to a particular broker through whom he is having an account, and trade in some other name through that broker, so that he will get his transaction squared off during the day itself. So because of this technological advancement, earlier what was a small problem which was invariably happening in the broker's office has now mushroomed, or it has become a greater menace in the system, because there are multiple avenues to pass on this information and take advantage of that. Now, and yes, what we found was in the last 4 or 5 years that this is happening because there are many large clients, or there are many large dealers in the system. One point of time, we were having only one or few mutual funds, or LIC was the biggest, from the institutional investor. Remaining people were all, not that type, or FPIs were there. But today, if you see, there are portfolio managers, very big size. There are number of mutual funds. There is, LIC. There are many other institutions, banks. There are many people who are having the capacity to execute large orders. So any person who is coming into knowledge of this big order, ensuing big order, can take advantage of this information, and if he trades, that we call it as a front running. Now, what happens is that in this case, the person may think that it would be difficult to be caught, but unfortunately, the trading pattern will itself demonstrate, irrespective of whether he is willing to accept it or not. As I said, how come whatever I buy and sell, always my second leg of the transaction will always match with one particular big client. If any of the participants are seeing the Axis Mutual Fund order of passed by SEBI, you can see those entities, 20, 30 entities which SEBI has taken action. Invariably, more than 90% of the transactions were matching with one particular institutional investor. How was it possible? I mean, unless you have the information about the transactions to be executed by that institution, it will not be possible for you to match your transactions, because today the system is anonymous, order-driven system. So how does a person know that who is on the other side? But in front running, it is very easy to establish as far as trading pattern is concerned. But unfortunately, the way our judicial system functions, they expect that mere trading data evidence is not sufficient to make an allegation of fraud or unfair trade practice. SEBI has to go one step ahead and then establish how this person got the information about the ensuing big order, so that both the person who communicated this as well as the person who took advantage of this information can be punished under the law. So this cannot be called as an insider trading, because in insider trading, predominantly the non-public information, which is called material non-public MNPI, which is called in insider trading as UPSI, pertains to a particular company or a particular corporate entity. But here in front running, the material non-public information predominantly pertains to a transaction which is to be carried out by a particular entity. It may be a corporate, it may be an institution, it may be a AMC, it may be a bank, it may be a FPI, anybody. Even we found a case where in a particular broking outfit, the director was doing a proprietary transactions. Obviously, to do his own transactions, he has to employ somebody to execute the order. The director is not going to sit and do a punching. Now, the person whom he trusted as his employee and given his orders for execution, he was actually front-running his own boss's transaction. SEBI has passed insider order, interim order even in that case. So, the point is, it was very surprising for us when our alert system proved that within the same broking outfit, the one person was making money, always his transaction was matching with a person who is a director of that broking outfit. Then, I do not know how people are so careless, or they think that, we will never get caught. So, the point I would like to say is that this is becoming a bigger problem in the system, because lot of big order clients are coming today. Therefore, there is availability of material non-public information about the impending transaction, and many people are thinking that if we take advantage of that, we can make quick money in the system, because all these 99% of these transactions are intraday. So your obligation of giving delivery or making big amount for the purpose of settlement does not arise, because you always take the square of position at the end of the day and then you make the money out of it. Now, as Mr. Pawan pointed out, today most of the transactions takes place through the digital devices. Very rarely people go to the broker's office, do any transaction, because of course there are some people who still do that, as we don't go to bank. We all do everything through our mobile or our net banking system. We do go to banks at times only. Same way, since these transactions are taking place through the digital devices, SEBI finds it difficult to get the evidence except for doing a search and seizure. So wherever possible, what we are doing nowadays is that in order to get the digital evidence, so that it becomes strong as far as making an allegation is concerned. And in Axis Mutual Fund also, we have done that. We did search and seizure. We seized the devices from where we come to know that who is passing the information to him. So we normally call the person who is having this non-public information as the information carrier, and the person who actually trade as the person who makes money out of it. So we link these two people, and then we say that this is a prohibited transaction, and therefore, since you have executed such a transaction, we call it as an unfair trade practice, mainly because you are taking advantage of the information asymmetry. Therefore, this should not be done. It is very important for anyone who receives this type of information should not act upon that. You should simply keep it to himself. One cannot make use of this MNPI. If someone makes use of it, MNPI for his personal purpose, definitely it will be treated as a violation, and accordingly actions will follow. And going forward, I hope people will learn from the order SEBI has passed, and I hope that the market intermediaries will maintain better systems to avoid this type of thing. And slowly we are bringing out responsibilities on the AMCs, on the institutions, on the brokers, to ensure that this type of information is not misused in their own office. If it happens something elsewhere, you can't blame. But how can, for example, Axis Mutual Fund, a person who is number 2, number 3 in the hierarchy, he passes on the information and uses proxy names to trade and makes money out of it. Which is it is like you stay in somebody's house and you steal in their own house. How can you do injustice to the own employer? So it is a very big what you call in Mr. Pavan said, it is unethical. Absolutely, it is I can say to the extent of it is a betrayal of what you call the trust. And the market is very, very important. Integrity and trust is very important in the securities market. When these type of transactions take place, the trust is being affected, integrity is getting lost, and therefore these transactions have to be dealt with severely. And that is why SEBI levies disgorgement, SEBI levies penalty, both monetary as well as non-monetary. So far, we have not taken up the cases for prosecution, but going forward, I'm sure a day will come when we have a very strong evidence, and if this practice goes further up and up, there is scope even for going for prosecution, and then the people who are doing that may land even in jail. So that is the severity of the punishment, and therefore people have to be very careful. We will actually, my colleague Mr. Ali Mitwani, who has been working with me for the last 3 years in this surveillance department, we have done few cases. He will demonstrate 2 cases where what type of evidence we collected and what is the process, because those orders are on the SEBI website. So you will, as Mr. Pavan said, how much effort we need to take, especially in this digital transformation which is taking place in this country. We need to learn a lot of things, how to correct the device, how to break into the device, how to get back what has been deleted. So there is a lot of things needs to be done. But of course, SEBI is gearing up with its own technology tools and other things, and he will demonstrate in a couple of cases how we have done it, and we all can understand from that. And once again, Mr. Pavan, I thank for inviting me, and for this wonderful opportunity. I look forward to from other participants so that we can learn something more on that. Thank you very much.
Thank you very much, sir. Thank you for giving the nice introduction, and everybody can understand the depth of knowledge relating to this front-running issues, which I initially told it is not easy to crack. And now I will request Ravi Prakash to just explain the law part, that what is this law, and then I will request Ali sir to give it some case study that how they have done, and then when he will cover certain points, then we'll do question answer. So anybody who has any question answer, please keep it ready. I have received various questions which is ready with me. I'll do. Ravi, over to you. please explain this particular aspects of law.
Thank you so much, sir. And I think the tone set by Sundareshan sir sums it up all, as he has very lucidly explained what are the challenges, the conceptual framework of front running, and how it differs from the insider trading. Although one may say that both front running and insider trading share the same genus because of the semblance or because of the umbilical cord, if I may use that word, of the asymmetry of information. Because in insider trading as well as in front running, the access to information which is not publicly available is crucial, although the elements are little tweaked. And I will come to this later when I'll be discussing about the nuances involved with this concept. But let me start with the basic genre of the frauds in securities market. Could you please put the next slide? So as you have many times said, and I have borrowed these portions from your presentation, Pawan sir, because this is essential to set the context. So it is the game of greed and fear. So it's all in securities market. There are two main emotions, which are greed and fear for investors. And as the name itself suggests, greed is making more money by any means, and fear is of loss or getting caught. And then this old adage, lobha papasya karanam. So what is fraud? In general parlance, or after analyzing and synthesizing the definition given, well, I do not claim that this is a ubiquitous definition, catch-all definition, but it's an attempt to simply put down what could be considered as fraud. Any deliberate or intentional act of deception is a fraud. Any misrepresentation or omission of fact by a person, knowing it to be false, is fraud. Any misleading inducement is fraud. And any interference with the principles of the free market, demand and supply, that's also fraud. Next slide. While there are many types of frauds that surfaced over time in the securities market, and while these are not the only ones that are there, there are many others, and there would be many more, because we are dealing with something which has its root in the human psychology and the opportunistic behavior. We are concerned today with only this one type of front running. So next slide. Next slide, Shivam, please. So where all this word is defined, interestingly, neither SEBI Act nor any regulation, except for the Mutual Funds Master Circular, which was issued in 2020, it defines what is front running. Regulation 4, Subregulation 2, Clause Q of PFUTP regulations, which prohibits any fraudulent or unfair trade practices in the market. This lays down the ingredients of front running. It lays down what is prohibited. But there is no definition. The definition is usually taken by SEBI from the lexicon by P. Ramanathan Iyer and from Black's Law Dictionary. And in both these lexicons or dictionaries, it is very clear, which was also iterated by Sundareshan sir, that someone placing an order in securities or someone dealing in securities based on information available regarding an imminent transaction, which would create an impact in the market. So what does this tell? Is that it must be based on some information that I have but others do not. It should not be a generally available information. The information should be potent and specific. It can't be a speculative information. It has to be a specific information where I'm aware about when that transaction will happen, who is going to do that transaction, in what script, and around what time. And thereafter, that information must also be susceptible to causing an impact in the prices of the security. The impact could be of catapulting the securities upward or thrusting it down, but the impact should be there. Can we go to next slide, please? Next slide. So the law governing front running in India, it is the FUTP regulations that governs front running, and section 12A, which is the mother provision embedded in the SEBI Act under which the regulations are framed. They both term this activity illegal. So there is no doubt that the front running is squarely illegal, not only for intermediaries or registered brokers, but also for people or individual or persons who are not intermediaries or registered as such. They both come under the ambit of these regulations because these are posited under FUTP regulations, which apply to everyone who has any concern or who's dealing with in the securities market. So by that umbrella, it captures non-intermediary as well as intermediary. But even this aspect took some time to be established. It was for the issue first arose in 2012-13 when SAT passed an order and said that no, it would not. The provision is not worded in a way that it would have its application on a non-intermediary. Ultimately, it took Supreme Court to render a decision and clear the air that the offense of front running can even be committed by a non-intermediary. So as we discussed, Regulation 4, Subregulation 2, Clause Q of FUTP regulations, it details out what is a front running, what is prohibited. And I told what are the elements which are necessary, or so to say essential for the offense of front running. Then it is penalized under section 15HA of SEBI Act that deals with the penalty, which provides for a minimum penalty of 5 lakh rupees, but it can go up until 25 crore or 3 times of the profit, whichever is higher. Next slide. So we'll now talk about the elements, types, and patterns of front running. Briefly, please, audience, I would request audience to understand that this is a topic which is ever dynamic. There, one cannot safely say that these are the only patterns or elements by which, through which front running manifests itself. One may say 1,000 elements, and I doubt that it would still be suffice to build an exhaustive list of patterns and elements, because there could be many, and it is a matter of human ingenuity that people come up with new schemes, new ideas to manipulate. And same is the case with front running as well. In fact, in this journey or saga of tackling the menace of front running, SEBI has itself seen some common modus operandi, but some very intelligent or innovative modus operandi that were deployed by defaulters to front run and hurt the market efficiency. So as we are discussing, key elements of front running, one is very obvious. You must have some access to non-public information. It should be a meaningful information, which means that it must not be speculative. It must be a credible and concrete information. Then there must be trade or on order. There must be dealing of securities based on this information. the execution of trades, but let me put it more clearly because this word would not suffice. And technically speaking, this would be incorrect to say that execution of trades. It is the placing of order ahead of the client orders or the last tranche of the client order that would make you fall under the dragnet of front run, regardless of when the trade is happening. And then knowledge of the client orders, advanced knowledge of a client order, execution of personal trades. So if someone is employed at some organization and that organization has decided to conduct a bulk trade or a large trade in a particular script, and somehow the employee or the agent gets to know about that information, the person need not to be an employee technically. He could be a consultant, a fiduciary, or an unconnected third party. If he somehow directly or through somebody else gets access to that information, the specific information about what is the trade size, when the trade is going to be in which script. These three, I think, would suffice for that person to front run that trade. So it is also called as piggyback right. Before you go into the market, you already know that there is a trade, a big trade, which is going to cause an impact in the market. So as rightly said by Sundareshan sir, the person, instead of taking the market risk, latches on, or so to say, rides on the piggyback of that order to increase the chances of gains. But by engaging into this, what they eventually do is that whatever impact is generated because of the interaction between buyers and sellers, which ultimately leads to price discovery, they eat that opportunity. They corner that opportunity in a disproportionate way, and absolutely based on that non-public information that they had, but others didn't. So that is the culpability of front running, because somebody merely based on asymmetry of information was able to corner the gains or was able to mitigate the losses at the cost of other investors or market at large who were not aware of such information. So here, because of this principle-based approach, which we see also in the concept of front running and the way SEBI wishes to regulate it or penalizes it, that I believe that it is a subspecies of insider trading. In fact, in United Kingdom, you see that there is no separate code for front running, but it is dealt by the legislation meant for curbing the insider trading activities. And similar to insider trading code of conduct, many jurisdictions have code of conduct for front running also. Although, technically speaking, and on a closer scrutiny of regulations, these code of conduct are also built in our regulations, multifarious regulations, apart from the recent amendment brought in mutual fund regulations through via circular. Even the stockbrokers code of conduct, investment advisors code of conduct, or research analysts code of conduct, all of these invariably require them to act fairly and with integrity, which essentially means, and not to put themselves in the conflict of interest position. But there are some jurisdictions where they have more. I mean, this is in India, what we are doing is a principle-based approach, telling them broad principles to be guided by. But there is nothing to prevent front running, at least at intermediary or mutual fund level, as is the case with other jurisdictions where they have made code of conduct. For example, SEC in USA, there is a thrivent code of ethics on front running, which is meant to curb front running and lays down guidance that what you cannot do. There are provisions of preclearance as are there in the insider trading law in order to curb front running also. But I'll come to that later on. Next slide, please. Types of front running. Well, these are only few examples of front running. One is the TP front running, in which someone is tipped by a person who has the direct knowledge about a future transaction that are going to take place, and he tips somebody else, and the TP then front runs the large order or large trade. Then second type of front running is also called offsetting front running, wherein you yourself front run your own trades. Then where an intermediary or any other trader who has access to information ahead of anticipated block transaction. So block transaction, it is essentially the same, that you know about a block transaction. A big block transactions are usually big. A transaction which is material enough is only categorized as block. So if you are aware about, as an intermediary, you are aware about a impending block transaction, and if you take a conflicted position or a position by which you wish to encash parasitically the impact that will be generated because of this block transaction, that's classic front run. And then the most common modus operandi on which there have been series of orders, including the CNBC order, which was the much celebrated one, where you are a public figure, which means that you have access to the loudspeaker through which you can influence public decisions, usually via social media or news channels. And then you use your own employees and agents to encash on the opportunity, because you are sure that whatever you will speak through that loudspeaker or the megaphone, it is going to influence and induce investor. But before the investors act, you have put your team to act accordingly and ensure that you book most of the profits caused by the impact of inducing and bringing the investors to a particular script. Next. So there are two patterns: buy, sell, and sell, buy. Invariably, in all cases of front running, wherever there is an allegation of front running, either of these would be present. One, buy, sell, is a profit maximization approach of front running, and sell, buy is, so to say, it's also profit maximization, but it's in a falling market. So the first BBS is deployed in a bullish market, and sell, buy is deployed in a bearish market. And I'm not talking about long-term behaviors of market. These are evaluated based on, what kind of impact the impending transaction is going to have on the script. If it is a big sell transaction, which would not naturally cause buoyancy and would rather push down the prices, SSB is adopted by front runners. And when the impending transaction is a large buy order, they usually do buy, sell. Next. So what is SEBI's investigation modus operandi? I think succinctly put by Sundaresh Sir. Communication records, financial transactions, and relationships. These three pillars under which several bookmarks are made, and on each of them several issues are highlighted. On each of them investigation is done. But these three are the trifecta of the investigation focus which SEBI utilizes to crack down the front-running menace. Apart from this, when we say financial transaction, this also include the transaction in securities also, the pattern, because the surveillance system tells about the proximity and the unusual proximity of an individual's transaction with large orders that are being placed or large transactions that are being executed. So if that appears repetitively in the surveillance system, it is red flagged and then sent for inquiry or investigation. Next. Then what is the surveillance method? One is that you are continuously monitoring each and every trade that is happening in the market, while it is happening in the market. Then data analytics of the trade logs compared with the order logs, and the pattern of placement of orders, which is cross-functional, not just of one entity, but it is compared with another entity as well. And then collaborative approach with other regulators to aid investigation or to aid receipt of information regarding the particular individual or persons. Next. So this is important as how front runners, they operate their schemes. One is that access to information, which is the key aspect. Even if all other things are matching and there is no access to information and precise information, the charge of front running can't be established. For example, and with respect to this access of information also, there are multiple theories, but let us focus on two primary ones. One is that when you access the information through legal means, which means that you are in possession of this information about a large trade in the ordinary course of your duties. It could be fiduciary duty, it could be a duty as an agent or as an employee. And you abuse that information to deal in that security yourself, or you tip it to other. So number one is when you receive the information legitimately, but you abuse it. And the second type of information access is when both the access to information and its abuse. Well, if the first leg is itself illegal, the second leg becomes illegal itself. But I'm just explaining that in situations where even the first leg is legal, the second leg of illegality could make the entire transaction a front running. Then next type of modus is that you encash on relationship with clients and you seek information. Then media manipulations, as I mentioned, CNBC matter. Hush trades using accounts of family members, that you have information, you trade through your family member's account. Next. And then what is the standard of proof? So the standard of proof is not clinching evidence, not beyond reasonable doubt or beyond any doubt. The standard of evidence to prove front running is preponderance of probabilities. But please do not confuse this concept of preponderance of probability as only a probability test. The word preponderance is of key importance because this is the test of a reasonable man. This, in simple words, that is the test. That is how the courts define this test, in which what essentially is checked is that the hypothesis of guilt should be such that it does not allow any other reasonable hypothesis of innocence to cut across that hypothesis of guilt. When applied to front-running matters, what it entails is pattern analysis, statistical evidence, which means the matching proximity between a large number of transactions executed by the front runner as well as the big client or the person who placed the big order or big transaction, connection between the alleged entities, the behavioral consistency, and that behavior should be unusual as well as consistent, and then the transaction record. So based on all these documents or analysis, whatever outcome emerges, that may lead to preponderance of probabilities, which is a crucial aspect of evidence in penalizing defaulters under the securities law regime. Next. So we did discuss about this earlier. How does front running impact the market? It provides an unfair advantage to the front runners because, of course, the basis, the foundation of their interest in a scrip or their dealings in a scrip is based on asymmetry of information. and not their own research or knowledge or gut feeling or their own genuine interest. It also undermines the market integrity by manipulating the stock prices, because front running is per se manipulative, not manipulative to the stock, but manipulative vis-a-vis the other market participants and investor. Therefore, it undermines the market integrity because you are not abiding by the rules of the game. You are playing the game, you are winning the game, but by unfair means. Erodes investor confidence in the securities market. It is but obvious when the impact caused by a large transaction is eaten out by a person or a group of persons who are deploying the front-running, menacing strategies. It is natural that the market efficiency would lose out. And that much, the profit that is cornered is not going to get distributed or equitably distributed or distributed in accordance with the demand and supply norms across the market participants, but were cornered by a few front runners. So therefore, other investors lose confidence. Then financial distortion, of course, it leads into financial distortion also and disturbs the level playing field. Next. Punishment and enforcement. So for SEBI, sky is the limit. I think a lot of avenues are open for SEBI to enforce and curb down these menacing activities. One is that passing orders for disgorgement, which could be passed ex parte ad interim. Second is monitoring fines, monetary fines under Section 15 HA of SEBI Act, market bans as a measure under the series of Section 11. And apart from all these, a prosecution also under Section 24. So let us see some judgments. We'll just skim through it because Ali sir is going to cover it. Or we can just skip this part, Shivam. Let us see the international point of view on front running. Next. So conceptually, it remains the same. The purchase or sale of a security in anticipation or of and prior to any execution of similar transaction for clients. The intent is also similar, which is to take advantage of or avoid changes in market price expected to result from the client's transaction. Next. So this is the Thrivent Code of Conduct that I was mentioning. This restricts personal trades and puts down internal control system how personal trading cannot be done unless until that impending large order or that information based on which front running could be executed, that information gets disseminated into the market symmetrically. Then there is this FINRA rule 5270 that also takes into this is the rule in US jurisdiction that takes into account even non-intermediaries. Although there is no such legislation in India, the point whether intermediaries and non-intermediaries both could be punished for front running is decided by precedent, not by a legislation passed by Parliament or a regulation framed by SEBI. The regulation framed by SEBI was interpreted in such a broad manner to include both intermediary as well as non-intermediary under the dragnet of the concept of front running and its punishment. So, no member or associated person to an intermediary is allowed to place an order to buy or sell a security or related financial instrument. The prohibition applies if they possess material non-public information about an upcoming large transaction. So you see, in US also there is a semblance with insider trading. In fact, the same word, material non-public information, which Sundreshan sir also said, it is equivalent to UPSI, which is used in India in the context of insider trading. You see that is used in FINRA rule also. So that proves there is some semblance between the two, although for enforcement and surveillance purpose, there are different concepts. I mean, it has been carved out from insider trading. But we also discussed about an international regulator, which is enforcing the concept of front running through insider trading legislation only. Next. So knowledge remains a common element. So we see and we are satisfied with the approach that so far as the principle or the philosophical approach is concerned, we are aligned with the global best practices because we are also tracking the knowledge, the element of knowledge. Next. Yes, now then publicly available information. If it is a publicly available information, that becomes an exception to the front running. If something is publicly available based on which I have traded, that will not be a front running. Next. Then there are exceptions. While our law does not provide for exceptions, but our law only tells what is considered to be illegal. If you do not fall within that bracket, it is not illegal. But in the Western jurisdiction, they have told what is covered and what is what are the exceptions out of it. Next. Next. So yes, this is a these are few cases which we sourced from the international jurisdiction. Here, what had happened is that the confidential information was misutilized to buy the sterling, which is a currency, in advance, and based on the knowledge of a large currency exchange transaction that this company was planning. And this caused a lot of profit to be made by the defendants and HSBC at the cost of the market, because they had the confidential information which market did not. And there were also allegations of manipulating the market price of sterling by executing transactions that increase the currency price and false representation. So it was a mixed case of main board fraud with some part of front running involved. But this was one of the landmark decisions so far as front running is concerned. Next. And then here, Mr. Govsky, a trader at a Canada-based management firm, he continued this for over 6 years. And there were more than 600 instances of front running where he was using insider information and tipping it to his friends, family members. And he generated $3.6 million in profits. So same classic modus operandi. I'm so sorry I have a bad throat. Please kindly bear with me.
Ravi, all these cases, the international cases, you can just skip all these things because Ali sir has to speak.
Sure. So I'll just wrap it up, sir. Yeah. So this is the FCA, Financial Conduct Authority on front running, which follows the same model of insider trading to even regulate the front running activities. Next. You see the elements are all across same. I mean, across jurisdiction, the same elements are using. Next. That some exceptions are provided for market makers and underwriters who do not have that information. And in some jurisdiction, if you take consent to trade, that consent is treated as an exception of the front running. But in India, that is not so. Next. Next. In these cases, again, we would supply these cases as a part of webinar. So that's all from my side, sir.
Okay. Thank you, Ravi. Thank you very much for giving a journey of Indian to international and then interesting cases on this. Now, I will request Ali sir, because we are just waiting for his presentation, that how SEBI is doing this complex thing and in the decided cases, what experience they have gained and what are the problems they have faced when they were doing. Over to you, Ali sir.
Hello, am I audible?
Yes, you are.
Very good evening. And thank you very much, Mr. Pawan, for inviting me again for this seminar. And as Mr. Sundeshan pointed out, it's a very interesting seminar where, you learn rather than giving more, you learn more things when the speakers speak. And Ravi has given a very good insight about what is in front running and how it is there in other jurisdiction. Ravi, I would love to have your slides, especially of the international experience. I would be very grateful if you can share
Most
it.
certainly, sir. Most certainly.
So many things have been said, so I'll just come and start something. What we do, we, as pointed out earlier also, we have a system where we generate alerts. And in alerts, we come to know if there is a pattern where we find there is a front running happening. So this is a software which has been developed where we have used analytics and other, even we are working on AI and ML on that. So we get patterns where we feel that there is something which is going on. And when the pattern is thrown, we have a big team in surveillance department who work on these alert. And then our journey starts in the world of front running. So basically, I being belonging to the surveillance department, we generate cases, and then those cases are sent to our investigation department to work on it. So in front running, there are three major players on whom we concentrate. The first major player is the big client. These big clients are whose trades are being front run. I'm not saying they are involved into it. Till date, we have not passed any order against any big client, but I feel in future maybe because possibilities that front runner and the big client possibility there is some connivance. No time will say what will happen. But big client we have HNI, we have mutual funds, PMS, broker, and even FPIs. We have seen cases where FPIs have been front run. There's important entity in this full front running is the information carrier. This is the entity who has access to the non-public information of the big client order. He is the main person in this full scenario. Usually, we have employees of the big client or at the broker's office. Till date, we have found these two things. I had written earlier dealer, but I deleted it because not necessarily the dealer who is punching the order for the big client is the information carrier. I came across a case where dealer was sitting and besides him, there was another person. He was hearing his conversation and he was putting the orders, he was front running. So either employee of the big client or of the broker can be an information carrier. Now, the next important thing, who are the front runners? Front runners are entities in whose trading account front running trades are being executed. Sometimes people, there are a lot of fools in the market. So dealer himself does a transaction in his own account. But when SEBI caught few cases, so people have become alerted. So usually they do into relatives account. But lately this has also stopped because people started knowing that if a dealer is, because the information is available with SEBI. So if dealer is there, very easy for us to find out the relatives. People think, kaisa dhoondta hoga? No, it's very easy for us. My team we have a lab where just putting some parameters and we can come to see kaun kiska related hai, kya hai. So people have stopped doing that also. Friends, yes, friends are there. But today is 21st of June. And after 10 years, we will find a footprint that we had attended a seminar hosted by corporate professional. Or last year, 21st June 2023, we can have a footprint where I was. Like, sir, you're in Dublin now. You have left your footprint there. And it is very easy for anybody to find out. And, we have Google, which gives a map line for you, okay, where you had been, how many kilometers have you traveled, and blah, blah, so many things. And we enjoy sharing things on internet. As an investigator, we enjoy that. Let people share things on the internet, on the social media, because these are all things which help us and you keep your footprints everywhere wherever you go. So it's very difficult to say that, I'm not leaving any footprints. About almost 20 years back, there was a study done in UK, in London. Okay, if a person comes out of his house for office in a particular day, how many times he is clicked? So they said 40 occasions he is clicked. That was almost 20 years back. Now you can understand. I think you can make a full reel of a person leaving his house and returning to his house. And you see most of the crimes are caught on that basis only. So now people have started using mule account. What are mule account? Mule account are accounts of, there are different ways. Sometimes they use mule account, you can call friends account a mule account, where as a friendship, somebody lends you to use his account. Then there are people who give their account on rent. Rent. I'll give an example, very interesting. Had an opportunity in one of the investigation to call the person on whose account trading had been done. So when we called that person, I asked him, and he was working in a post office, outside a post office, not earning much, 2,000, around 5,000 rupees per month. So I asked him how you have done so much transaction. These are not your transaction. He said, I meet somebody in train regularly. He told me, I'll pay you 2,500 per month. You have to only just sign these documents, and whatever communication is received at your house, you have to give it to me. Bas. For 2,500, his account was used for crores of rupees. Another example, there was a blacksmith, he was making jewelry, and a poor guy, and we landed at his house 6 in the morning. So we thought, ye to bahut paise wala hoga. So pata chala, he had also lended his account to one of the person whom he was working, and his account was used to trade in the market. So these are the mule account. A lot of things have come about mule account. We have one order on SEBI website of October 1st, 2020, front running. In that, a very good discussion of mule account is there. In that case, I'm covering somewhat. But you can, if somebody is very interested in knowing, mule account, driver's account, gardener's account, or servant account, all types of account come under mule account, and most of the trading happen in mule account. Then we have this, Ravi has pointed out, BBS and SSB, buy, sell, and sell, buy. I'll take an example to just show what is buy, sell, and sell, buy. This is one sample example. Front runner comes in the morning, in the afternoon, 12:32, 22 seconds. He places an order for 17,000 shares of company XYZ. He puts a buy order of 335. Okay. And his trade takes place at the same time, 12:32, 22. It was a market order. And the rate was 335. Quantity traded 17,000. So 17,000 shares he has traded. There's another front runner who comes at 12:32, 28 seconds, buys 1,700 shares at 336, ordered, done. There's another front runner who does similar trade, 17,000. So totally you see 35,700 shares have been dealt by front runner 1, 2, and 3. Now what happens? This will show how this is buy, the first leg, BBS, buy leg. So the front runner, on knowing that there is a big transaction is going to come, he trades before the big order comes. Now the big client comes, and see the big client. What is shaded in the blue color, you see at 12:32, 38 seconds, the big clients come and he places order of 34,000 at 337, and trade takes place at 12:33, 33. Okay. Now, when a big order comes, the script, 34,000 shares coming, there will be impact, there will be movement. So what he did, that movement is there. After that, just the order comes, the front runner, what he will do, he puts a sell order. See, 12:33, 19, he puts a sell order of 17,000, and that is match exactly, total 17,000 is matched with the big client. Out of 34,000 shares, 17,000 is matched, even FR2 and FR3. That's very interesting. The FR has made a profit of 1 rupee 90 paisa on an average. But if you see the shares are almost 34,000 shares. So he has made 51,000 rupees in a time between 1 minute and maybe you say 2 minutes. In 2 minutes, he has made 51,000. Good business. अगर दिन में ऐसे 2-3 transaction मिल जाए, so you're taking this is a small example, 50,000. We have seen people making in lakhs, even in few lakhs. I've seen 20 lakhs in one transaction if the quantity is big. So this is buy, sell. So before the big client comes, you buy. And when the big client comes, you put an order and you match with your sell order with him. So that momentum which has been created because of the big order, you make money. See, money, you will feel कि 1 रुपया 90 पैसे में क्या होता है? 1 रुपया 90 पैसे में बूंद बूंद से ही दरिया बनता है. Okay, so they do this thing and make money. So now big client order is known by the front runner and he does it. Sometimes this BBS is very interesting. It is BSB. आप बोलेंगे कैसे ना BSB. So front runner buys, he puts a sell order also. And sell order is put far away when he knows if the prices go up, what will happen. So nothing will happen to that order. So buy order, sell order of the front runner. And when the big client comes, it matches and he makes money. So, you know, the fraudster, they were doing BBS. They thought, let's do something else that SEBI will not catch. But we have got that also. I'll share with one more example. So this is the typical way of BBS and similar is SSB, that is sell buy. I'll take a case study. This is a case study of, if you read it, you will come to know it's of LIC only. So in LIC, there was a dealer and he was aware of all the big orders of LIC because he was a dealer. What he did, he opened account in the name of his parents, father and mother. Don't be surprised, we have written father was deceased, you know, father had already expired. So his father account, bank account and trading account was already there. And in the name of in-laws, he opened the account. So what he used to do, because he was a dealer, so he was knowing when the orders are going to come. Before the LIC fund manager used to give order to the dealer and dealer had to place with the broker, he used to place order in the account of his father, deceased father, mother, and mother-in-law, and sometimes in mostly mother-in-law, not in father-in-law account. So there was significant transaction, and the best part where we found was that the machine ID was same for the device, you know, from where he was putting order for the father, mother, and mother-in-law. And, you know, total in 2 years, he made almost 2.6 crore. His salary was not much, but he made 2.6 crore through this modus operandi. Yeah. The question is how we came to know. As I said, we have alerts throwing up to our teams, and the alerts are picked up. The team went deep into detail, and not just computer output we did some human intelligence. We talked with people, got some information. SEBI has access to the call data records. Everything was done, and finally, you see machine ID also. We got the brokers from broker also. We got a machine ID, another thing, and the case was, you know, we were able to take it to its logical end. This case, confirmatory order has already been passed. The final order will be passed very soon. So this is one case. It is already available on the website. It was passed on 27th April 2023. It's almost a year and more than a year. 1 year to 2 months. So this was one case. This I've just got one example. This LIC matter. He buys before the big order. See, in this case, he puts a buy and sell order at one time, and then the big client order is put. So he places the order at 155 for 5,000 shares. He puts a sell order also for 5,000, but the price limit he puts is 11,000, 116.150 paisa. And then the big order comes, and this is matched. So in this particular case, he tried to deceive people that, you know, this is a genuine transaction, but we were able to find that it was not so genuine transaction. Yeah. I'll take you to case study 2. This is very interesting. My team had done a very fantastic job. They were on the field to get this cracked. And this happened during COVID, you know, when COVID was there. So there were 6 big clients. And they had the 6 big clients, they had their own broking firm. In that, there was one dealer. So if you see dealer number, information carrier. So this information carrier was a dealer who was placing orders on behalf of the big six client. So he was knowing, and in that big six client, there was a mutual fund also, there was a PMS also, wealth management also. So he was aware of all the orders of the big client, and he was placing this big order on behalf of these six client. What he did, he used to transfer this information to another information carrier, two, carrier one, carrier two. And in turn, this dealer was trading in account of FR1, FR2. The other information carrier was dealing in FR3, FR4. So what they did, information came from one dealer, he passed on to another dealer. This dealer was having two front accounts, and the main dealer was having also two front accounts. And these all four entities are not related to anybody. That's the beauty of this case, you know. So dealer may, the information carrier, he was trading on behalf of two accounts. No information, nothing related to him. The second guy also, nothing related. But you know, जब चोर चोरी करता है तो he leaves lot of things for us. I don't say थोड़ा छोड़ता है, बहुत कुछ छोड़ के जाता है. And here we found out that whenever the order was coming, the order was placed through these four accounts. How they were passing on the information. And you know, these four people were not knowing also that the account was misused. When we saw their KYC, they were people who were earning less than 5 lakhs a year, but their account was showing, you know, crores of transaction happening. So we did bank analysis. In bank analysis, we found a very typical thing which gave us a new idea. We saw money, for the first money was deposit, which went to the broker. And from broker, the money was coming, you know, out from payout every day. And that money was being withdrawn, not transferred to anybody. आज की तारीख में digital fraud में ये होता है, पैसा transfer होता है एक account से दूसरे account से तीसरे account, but you have the audit trail. But till the time the money is in the account, the money is saved, you know, that can be frozen. But here what you used to do, like for example, the payout came of 1 lakh rupees. So somebody was, not somebody, we'll say the account holder was withdrawing 20,000, 20,000, 20,000. And in both the things we found, all the four accounts, the modus operandi was similar. Before this period, the account was a normal account, but now only money which is coming, it's not a salary, no in commission, no dividend, nothing. It's only which is coming from broker. And the amount is slowly taken out from the bank account. So we went to the bank and found out how this money was withdrawn. We got, there were 3 ATMs from which money was withdrawn. So we got the next thing. This is the video which we captured. We got it from the bank. And we found out the person who is, this is one picture I've got. We had got others also. We found out, ye shakal dikhi hoti hai. We have seen this person. And this person was none but dealer one, this one who was working for the broker and the information carrier too. So they both were withdrawing from ATMs, from different ATMs, and they were withdrawing. So what happened? These four front runners were not knowing anything. Their bank account, everything was with them. So one account we found कि ये गोरखपुर से पैसा निकाला. गोरखपुर कौन जाएगा? We found the dealer, the information carrier, his hometown was Gorakhpur. So when he was in Gorakhpur, he withdrew that money. In this way, this case was cracked by SEBI, and the case complete हो गया. अभी तो उसका आगे चलता रहेगा. So I'll not take much of time. You know, we can talk and talk. There are so many cases, but I will stop myself. It's very difficult for me to stop because once you go into it, you enjoy talking about it, how it was cracked. And there are many such stories. So I'll go to the final slide, a message. This all has been done. A message for not only industry, for everybody. First and foremost, you are being watched. You are being watched. तो आप कुछ भी कर लीजिए, you are being watched. If you try to play in the market, SEBI being a watchdog and a regulator for the markets, you are being watched. So वो जमाना चला गया कि पता नहीं चला किसने किसके अकाउंट पे कर दिया. It's very difficult to do that. So we would be very happy. We would like to convey this message from this platform of corporate professional. Please, you are being watched. Second, as I said, wrongdoers cannot escape because we all in today's world keep our footprints wherever we go. So after this, presentation, when I'll be moving out of my office to another meeting, I'll be putting my footprints there. Then when I'll go home, everywhere. So please be careful that you're putting your footprints. Don't think मैं अपना Google बंद कर दूंगा तो footprint बंद हो जाएंगी. ऐसा नहीं होता है. Third, technological advancement to catch frauds. We are far ahead, and I can tell you, in some cases, we are far ahead than the other jurisdiction. Other jurisdiction do not go in much detail what we have done, though we don't have some powers which we would love to have it. But without those powers, we have been able to use the technology to catch frauds. I wrote agent principal responsibility, a message for the market and for the intermediaries. Till now, we have been charging the dealers, the employees. It will not be far that we will go to catch the principal also, because it is their responsibility to keep their workplace hygienic. If they are not keeping their place hygienic and such things are happening which is affecting the market, so that we will be there at their place also. Next, all as discussed by Ravi, is detrimental to market integrity and its sentiment. And the next point, which wrong image to the world. See, India is a place where people want to invest. And you see the flow of FPIs, and everybody looking at India in returns and everything is a happening place. Now, if such thing happens, please see what will be the effect on our markets. It gives a wrong impression. You know, I tell you, all our SEBI people, when we meet our international people who are regulators, you know, हमारा सर ऊंचा होता है. We are India, we do this thing. But you know, such type of things which happen, and everything is in media. People see what is happening in India, which gives a wrong image to the world. So we have to be very careful. हम लोग Indian हैं, we have to be careful कि हमारा image बाहर जाता है. Next, think before you act. सोचिए क्या कर रहे हैं. कुछ पैसे बनाने के लिए प्लीज अपनी जिंदगी मत खराब करिए. I have seen cases very recently. A big guy, well known in the market, he has finished his 40 years of prestige and status is finished because didn't think. थोड़ा पैसे बनाने के लिए he अपने पूरी इज्जत को उसने दांव पे लगा दी. So think before you act. And finally, if you find anything adverse, SEBI is there. Let us know, mail us. We will definitely take it forward. Thank you very much, Mr. Pawan, and corporate professional. Thank you very much.
Thank you, Ali sir. Thank you. I think your last slide was the most important message to the entire market. To maintain the integrity, it is very important. And when you were saying supervisory responsibility, I was reading one case of SEC versus Stephen Cohen in 2016, where SEC Capital Advisors, they have this person has not done anything, but because he was a supervisor and overall doing this, the firm got benefited. So he was charged. So I'm hopeful, and it is sure that you will put responsibility to the agent, responsibility also agent. So it means that you have to keep your home intact. So thank you very much, and very interesting BVS and BSP. That is a very interesting point. And the way you have explained this, everybody can understand. It's not just a small amount which you are seeing, because every day thousands or lakhs of transactions are taking place. Even if every day you are minting 1,50,000, 20,000, you can just understand how much you are doing. And in a normal case, the interesting point is, which you are saying, that for example, the number is the same. The 17,000, 1,700, 17,000, another person is also putting. So you can understand the people are aware that I'm not minting more money. I'm just minting 1 and 2 rupees and my work is over. But very interestingly, the Gorakhpur example which you have given, how we have come out with this. Mohini, I will ask you, I'll give you only 5 minutes to you, because I have to ask public questions which I have received. So just give something point, and then we can over to the question answer.
Yeah, sure. So already Ravi and from SEBI officials, we have you already been aware of that there is a every insider trading and the front running. What are the differences between these two terminologies are there and two activities are there? So when we talk about the insider trading aspect in this front running, or how to insider trading can be involved in this. So as we all are aware of that, insider trading regulations are applicable on the listed companies. But in the insider trading regulations are also applicable on the SEBI intermediaries. In the SEBI and the front running cases, these SEBI intermediaries people are generally be involved. So now when it comes to whether in the front running cases, insider trading also be involved. So that important point in this is that whether the person, the employee of that intermediary, example, the broker, is in the possession of the information which is not in the public. So the front running, as already explained, that in the front running, the person is trading before undertaking or doing the trade of their order which he has received from his client. So now, if that information, that if it's a bulk trade or what he be expecting from that particular trade, because UPSI definition, what it says that the information is related to company or its security. It is the information not in public and it can materially affect the price. So if that particular information of that trade, if it comes in the ambit of the UPSI in that particular case, then definitely along with the front running, some aspects of insider trading also comes into picture. Now, so because if the person is found guilty in the front running cases, so that means it also comes into the, like everyone said, key integrity of the market and also the reputation of the person as well as to the organization as well, because that institution somehow be giving this signal that there is some cases wherein the internal control systems are not so much strengthening with respect to that the employees are not aware of their do's and don'ts, or they are also harming not only their image, the institution image as well. So if we talk about that, how through the, because there are in the insider trading as well, many of the aspects are there through which these kinds of activities of the employees of those institutions, those intermediaries can be controlled of. Like if I talk about the code of conduct. So every intermediary have the code of conduct as per the SEBI PIT regulations. So that should be very much clear. And the employees of those intermediary should have a very clear understanding about the do's and don'ts of those code of conduct when they are dealing in their restrictive list or any of the securities of their clients. So this is the important aspect, that enforcement of code of conduct is very much important for these kinds of institutions. Second, in the institutions, generally what we have seen, and it should be there, that the pre-clearance mechanism should be very much strong. Because many of the institutions which we have come across, they have that for every trade, they have to take and obtain the pre-clearance from their compliance officer. So compliance officer knows before it trades, yes, the person is going to trade so much of in these securities. So that is also which one of the mechanism which can be through the insider trading can be enforced into. Second one is that the compliance officer can implement and should implement the periodic trading disclosure mechanism in the organization, like quarterly trading statements of the person, or annual, half yearly, but quarterly will be better, so that it comes to know that in which scripts the person is trading into. Second is the strict enforcement on the employees with respect to the disclosures of the PIT, like the disclosures of their relatives information, like their parents, spouse, their children, because might be he not be doing it from their account, he can use their relatives account, like their spouse or spouse account or parents account. So in the PIT, there is a very strict instruction that the person has to give the information about their relatives. So if that is also available, then compliance officer can also enforce this provisions very strictly in this. Second is because as we seen in many of the cases, and as Ravi and Ali sir has said, that the person is doing buy sale and in a very shorter time. So in the PIT regulation, there is a provision with respect to the contra trade. So, and it is applicable on the listed this fiduciary as well. So this intermediary as well. So from the code of conduct, the contra trade provisions can be also strictly enforced so that the person can't take an advantage of these short positions. So only one way he can go, not the other round of trading activity, contra trading he can't do. So these are the few points from my side which can help enforcing the PIT regulations, and somehow it can also help pre-monitoring of this if it can be avoided the front running cases. Yes. So thank you. Thank you, sir.
Thank you, Mohini. Thank you. Thank you. I'm coming to the question answer session. So, Sundarshan sir and Ali sir, and few questions for Ravi and Mohini. Sir, I just want to understand what are the main challenges SEBI faces in detecting the providing front running activities? Sir, should I repeat question?
Yes, please.
Sir, what are the main challenges SEBI faces in detecting the and providing front running activities?
Challenges in proving.
Challenging SEBI faces in detecting and proving front running case activities.
Detecting is I will not say it is a challenge. See, the volume of transactions are so much. You know, the type of algorithms we need to write. And the important point is, if a person transacts 100 transactions in a month, out of that, if 100 matches with the big client, then we can say it is front running. If 70 matches, can we say it is because it is anonymous order driven system? And then in 70, how much money he made as compared to the remaining 30? If a person is very sure of what you call the matching this transaction, obviously the maximum profit he will make also should be from such transactions. So we need to apply multiple parameters before we pick up a particular alert for front running. Because tomorrow the person will come and tell that you are picking and choosing those transactions which are matching. I have also done transactions which did not match. So that means that is where the important aspect comes, whether how proximity is relationship with the person who is actually having this information. If the person who is having this big clients ensuing transaction and he himself trades, then the case is easy to prove. That is why in those cases we have come with interim order. But there are a number of cases where how the communication passed on, because the judiciary expects, although we all talk about preponderance of probability, but when the particular aspect is challenged, that the tribunal or the courts expect something beyond preponderance of probability. And in this, that something is nothing but if the person who traded and the information of a big client, if there is a gap, unless we fill the gap with concrete proof of communication under the existing legal system, the entity will go scot-free. So to pick up a particular transaction as a front running, if it is one-off transaction, we definitely can't charge. So the criteria is, first of all, it has to be disproportionately high. Now, what is disproportionate? What is substantial? Again, it depends upon the entity. If somebody has made in a year by doing this 4-5 lakhs of rupees, Do we have such type of bandwidth to go after all such people? So the challenge is first identifying the transactions and applying these filters, and then getting the connection between the person who had the information MNPI and the person who traded.
Sir, suppose I am doing transaction and that is matching in the market, not with the front runner's transaction is not matching with the client, but matching with the market. So how will you come to know?
Sir, now that is the next level of our going forward, whether it has to mandatorily match with the big client's order. See, so long, at least as it stands, 21st of June, we have so far taken up cases and charged people where substantial transactions of an entity matched with the big client's order. But I understand that recently there is a case which has come from SAC, which I'm not able to recollect the exact name. If you apply that ratio, which has been given by the appellate tribunal, probably we can go again with the charge these type of transactions where it may not have matched. But then again, the entity will come and say that how did you say that all my transactions were based on or while in possession of or with the knowledge of the big client's order? So that legal challenge will be there. But as on today, what you said is right. We have not considered those transactions which you cited as a violation. But if you strictly go by the section 12A as well as that 41Q, which Ravi was explaining, it will be tantamount to front running only.
Okay. Sir, how effective have been recently regulatory changes been in the curbing front-running practices in security market? Because you can't have it, you can't record telephone, you have some limitation as compared to international market. Because the one biggest things, I was just reading the case of this Gallon group, Rajaratnam and Rajat Gupta, where Rajaratnam get 11 years of imprisonment and Rajat Gupta 2 years. But in our case, in our India, we have not seen this type of any penalty. So is it the reason that regulatory changes which can bring out more power to SEBI that can bring out better results? So what are the regulatory changes do you think is required to SEBI?
I think it's a too large a question to be answered in a few minutes. But please do not compare the Rajaratnam case with the SEBI's cases, because please let me clarify that in US, the moment SEC feels that it is not a civil case and it is a criminal case, the case is given to FBI, which is equal to our CBI. Even SEC on its own does not have the what you call the tapping power. It's all, unfortunately, we immediately think that US is always better than India in many aspects. But when you go into the minute difference, you will understand that SEC engages FBI. FBI is nothing but equivalent to CBI. So here also, if we give this case as a fraud and hand it over to CBI, they can get the calls. They can get the transcripts. Only SEBI is not getting the transcripts. SEBI is not empowered to intercept. But the point is, to what extent the power of interception, even if it is given to SEBI, need to be examined in detail, because all these powers were with different agencies given at different points of time. Today, the laws are evolving with the privacy has become a fundamental right in India, everywhere it is. So every agency to be given that power, it's a larger issue that cannot be debated in one seminar. But SEC also, what it does as a civil case, it invariably goes for settlement. Only where it feels that no, it has to be proved from a criminal angle, Then it gives the case to FBI. And if you read the book of Rajaratnam matter, FBI goes to the court to get many things. Like SEBI also goes to court to get the warrant for such and seizure. So we all have powers which are definitely, what I will say is that sufficient enough to catch these type of transactions.
Okay. Sir, what message you want to give to the intermediaries? Like suppose I'm a dealer, I'm doing something wrong, but you are my boss. So what message you want to give to the all bosses, those under whom the dealer is doing something wrong? So internal control, internal system, what they should do?
Sir, if you, I think, when we came out with that Axis Mutual Fund case, subsequently, if I remember, the mutual fund industry has been sensitized, and certain instructions are being given to them that what type of systems and control they have to put in place in their respective offices to avoid this type of happening. Similarly, SEBI has amended, if I remember correctly, broker regulations, and made in the broker's office what type of systems and controls they have to put in. So these instructions have already been given. Now, there is no point in you are keeping on amending the regulation or giving instructions. The point is to what extent those people are sensitized and those people are being watched. So that, see, many things will, will happen only when there is a fear of getting caught. If that fear of getting caught, see, I mean, it applies to any human being that, many things we all don't do because we don't want to be seen on the wrong side. That's all. Otherwise, human nature is to greed as well as to try out new things. But people like you and me will not attempt doing something because we don't want to be found on the wrong side. So that type of culture has to be developed over a period of time that, if I do something like this, I will get caught. If I get caught, I will be punished. And if I get punished, it is a shame for me. If this type of cultural behavior changes over a period of time, then only these things can be, reduced. Otherwise, as long as greed is there in the system, these things cannot be eliminated.
Okay. Sir, most of the time, last two questions, sir, a small question. Most of the time before OFS is announced, we see a fall in price of script. Is this type of cases comes under the front running and become eligible for the investigation?
On what?
OFS. When the OFS is announced, there's a fall in price. But this is a demand supply game. This is not a front running.
OFS is done through the system. It is not known to only one person and dealt.
Yeah.
If I want to do a OFS, I'm going to, and substantial stock is going to come to the market. It can be bought by anybody. I don't think in OFS there is a possibility of doing that. But then again, if somebody wants to buy innovative ways, he can find it anywhere.
Okay, yes, that's right. Sir, I have identified some suggestions for stock running that enhance surveillance that you are doing, a stronger regulation that is in the pipeline, and educating and training like this we are doing. But the last most important point, whistleblower protection and the award to whistleblower. Are we working on that direction, sir? Because inside my bedroom, you can't get anything unless some inside person is telling and they are blowing the whistle.
Sir, in insider trading regulations, we have provided a scheme for whistleblower that we call it as an informant mechanism. We have increased the award to, I think, almost 1 crore. Till today, the regulation is almost more than 5 years old. Not a single case has come. So, insider trading is a case where if somebody wants to really blow the whistle, the information will be easily communicated to SEBI. There itself, the success rate is not satisfactory. So, for every regulation, if you bring a whistleblower, I mean, we have to go by empirical evidence.
Okay. Okay.
So I mean, that's what I'm telling again and again, hiking the law. Only this taxman publication from 4 volume, 5 volume, it will go to 6 volume. It does not make any sense unless the existing law is being used.
Yes. Yes. Okay. So thank you very much, sir. Thank you, Ali sir. Thank you, Sundarshan sir, Ravi and Mohini. Sir, as we are concluding the session, I just want to take your comments, final comments. Before this, Ravi, you want to say something, 30 seconds, and then Mohini?
So you want concluding comments, sir, right?
Yeah, yeah.
I think the architecture of front running is currently linked with FUTP, but I think it will be better suited, and that's for SEBI to evaluate. If it would be better suited by clubbing it with insider, or taking the characteristics of insider to develop strong internal control systems, at least for intermediaries. I understand the market is fairly big and they can't surveillance the entire market, each and every order. But I think the most vulnerable part are intermediaries, and there, if they can establish systems, I think it will help curb down this meanness by a big measure.
Okay, Mohini.
As already in my those remarks, I said that because many of the things are being given in the insider trading regulations as well. So if that be strictly followed with other suggestions as given by sir that and Ali sir, that informing the people and making them aware of that what the consequences they face, I think the things can be controlled.
Okay, Ali sir, your comments.
I will just reiterate, beware you are being watched and report to SEBI if you find any adverse thing.
Okay, okay. Well, your last slide should be make the reels and publish it everywhere that this is the message everybody should realize. Okay, Sundarshan sir, your final comments. Sir, you are there? So, so Ali sir, your that last slide should be the story of today's webinar. That that particular thing should communicate to everyone that you are watched. Like everywhere we see, जैसे हम लोग लिखा होता है ना, the CCTV, you are under CCTV. So people should think that SEBI has a different CCTV, which is being watched. And you are absolutely right. Today in the digital era, footprint of everybody. And I was just remembering one case of the insurance company where they have rejected one case of person who has mentioned that I am not smoking. I am not a smoker. And later on, the agent got the photo of that person who was going abroad and with friends, he was just smoking like this. So they rejected. And in your case also, you have given the photo of 4 friends, and you have mentioned that they have traveled abroad and they are close friends that you have given in your order also. So it is no doubt that human intelligence is also using, and you are one step ahead to वो हम लोग क्या सिस्टम है ना, चोर पुलिस से ज्यादा स्ट्रांग होता है, लेकिन यहाँ तो लगता है कि पुलिस भी अब स्ट्रांग होने लगी है, and that is the best part. Okay, so thank you very much everyone who has participated, and this type of programs gives a clear message to the market. And I think my basic purpose of front running case program was that it is not that how people are coming, how the people are seeing, but because we are putting this on our YouTube channel, so people are watching and making it. And now we have started putting reels also, the important point, so person can see, person can read, and they can understand. So by doing this, I hope that we can bring out more integrity to the market. And actually, this integrity of the market brings out level playing fields. And the level playing fields bring out the confidence of the investor. That is a very, very important factors which we all should understand. It is not a question of 10,000, 5,000, because I have seen SEBI has penalized people for 2,500 rupees gain, 5,000 rupees gain, and everybody asks that, "Aure, 2,500 रुपए में क्या कर दिया insider trade?" The question is not a 2,500 रुपया. The question is that whether you have done insider trading. Answer is yes. So you have created a something. You are trying to break the system. So today you are making 2,500 rupees. Tomorrow you can do 2,500 crore rupees also. So that's why we say it's a SEBI's duty that they should stop it at the beginning. So thank you very much, Ali sir and Sundarshan sir, for giving this. With this, thank you all and all the participants. And friends, this journey of knowledge sharing will continue. Our next webinar is 177th webinar on next Friday. That is revisiting significant beneficiary ownership under the Companies Act on 20th June, 4 p.m. Till then, see you there, and you can register. This is a very important, and it is for every company should understand the concept of SBO, because so many issues are coming in this. Thank you very much.